Hey everybody. Afternoon, good morning, good evening, good night to some folks. Thanks for joining us today. It's December 9th, 5 o'clock Central Time. Typically, you're used to seeing Rahul and Emily. We are fortunate enough to step into their stead. My name is Ryan Wilk. I'm joined by my partner Rebecca Chen. So yeah, we've seen some pretty interesting developments kind of over the last 24 hours. So what we were wanting to talk about today, we've kind of got four topics, but what we'll focus on mostly today is the pushback that we're seeing or the delays for H interviews or really all consular processings. Some of the expansion of social media screening, we've seen a lot of questions about prudential visa revocations and what that means, kind of how do we need to deal with that. And then last week, USCIS announced a truncation, a shortening of the EAD validity period for certain types of categories. And so we'll talk about that and some best practices so that we're finding ourselves in any issues. And so, Rebecca, what are you hearing about the visa appointment cancellations and kind of how soon do we think that we'll start seeing things resume at the consulates?
Yeah, so just this week, mostly starting yesterday, people with visa appointments, H-1B and H-4 appointments scheduled at consulates, mostly in India, although there have been some reports from some other posts now, are getting emails from the consulate saying that their scheduled visa appointment has been canceled and that it will be rescheduled to sometime in 2026. Some of them are the new rescheduled dates are months out, like in March, even June. So the rescheduled dates are several months away. The emails have not specifically mentioned why the interview dates are being canceled and rescheduled, although we have a feeling that it is related to the expansion by the Department of State of the online presence review to H-1B and H-4 visa applicants that was announced last week. So last week, the Department of State announced that it's expanding its social media review requirements to all H-1B principal applicants and H-4 dependents. So this is similar to the social media screening requirements that were imposed on F1 students earlier this year over the summer, as well as M and J visa applicants. But they're expanding that now to H-1B and H-4 visa applicants, basically to increase vetting of social media presence. And so some of the requirements are that now H-1B and H-4 applicants for visas at the consulate are instructed to set all their social media profiles to public so that consular officers can review their online content during security vetting. They are emphasizing now that every visa adjudication is a national security decision, and that Department of State will use all available information, including online presence and screening. So this is definitely going to increase processing time if consular officers are being instructed to, do this extra thorough vetting of all H-1B and H-4 applicants' online presence. So most likely that is the reason for this week, the emails that people are getting telling them that their visa appointments for December are being canceled and rescheduled for months later. Although officially, I think DOS hasn't come out and said that that's the reason for the rescheduling. Most likely, that is the reason. So our advice again, which is has been our advice for this entire year, is to not travel, especially if you need a visa stamp. So if you would require a visa stamp to re-enter the US and you are in the US now, our advice would primarily be don't travel. This is not the time to do it. There are people who are in India already who are getting ready to go to their visa appointments this week and are already there in India and now have their appointments rescheduled for months later. And there's not much that they can do besides waiting for their appointment. They can't re-enter the US until they get that visa unless they have some other visa available to them. I mean, usually that would be H4, but even H4s are subject to this increased online presence screening. The only thing you can do is just sort of check to see if there are earlier appointments available, but there's unlikely to be when, this is going to be happening for all H-1B and H-4 visa applicants. This is a real problem for people who are already abroad and who are getting appointment rescheduling notice, because not only do you have to now wait in abroad several months longer than you initially anticipated, but the risk is that if your H-1B employer in the US isn't willing to keep your job open for that long, to wait for your visa appointment to go through and for you to be able to come back next spring or next summer, then you won't even be able to really attend the visa appointment, or the visa will be denied because there's no longer a job offer there. So it is very crucial right now for everyone who is considering traveling, or even if you already have plans to travel and you have a visa appointment already scheduled, even if you haven't gotten a reschedule notice yet, I would seriously rethink traveling. Maybe wait a bit to see if your appointment gets rescheduled. Don't depart the US right now. We know this interferes with a lot of travel plans, especially over the holidays. This is, of course, an inconvenient time for all of this to be happening, but it's very important because it could lead to you getting stuck outside the US for, several months because of these increased screening requirements. And then Ryan, is there anything else to add on the social media screening? I know
before we hop over there, and is my audio okay, Rebecca?
Yes, I can hear you.
Okay. Yeah, before we kind of get into the social media, I know you and I were kind of talking earlier about kind of our maybe personal/professional opinions about this. Whether it is for the social media vetting or not, the whole purpose is to slow down immigration. So whether they want to give themselves a cover by saying this is, we're using social media to vet people or not, frankly, they're going to be using AI to do this, and this program could be vetting people instantly. And so the fact that they're pushing things out 6 months, me being a little bit more cynical than some others in the office, I think that there's a little bit more of an intent here. But to Rebecca's point, absolutely avoid travel. Just as a reminder, you can be in the United States with an expired visa stamp. That's very, very common. Your visa stamp is just your ability to re-enter the United States, not your ability to extend your H-1B, to change statuses, and so forth. And so do not think that you must go get the stamp. The stamp really just gives you that ticket back in. And right now, if you leave, it's going to be a minimum of 6 months before you get back in. A couple points is that, and Rebecca made a great point, that if you're stuck out the country, is your company going to keep that job open for you? Rebecca, you can correct me if I'm mistaken, but you can continue that job abroad. I often get questions, Ryan, am I violating my H-1B status by working in my job in India or in Britain or wherever the case may be? Simply put, as much as the government thinks that their authority extends beyond the borders of our country, the H-1B program is just simply not applicable in India. And so if you are abroad and working remotely for your company, that's fine and well in our view. And so just something to consider if you are maybe needing to travel or if you do get stuck out. Regarding the social media vetting policy, so this is kind of the second topic that we'll be talking about today. I think I can speak on behalf of the whole office. We kind of had a chuckle about this because this isn't a new policy. This idea of social media vetting has been around. I'm going to estimate, but at least 2+ years, if not even from 2020 era. And so it's been around for quite some time. I think this is just a way for the administration to create a little bit of a headline. We're doing so much to be protecting U.S. citizens. Well, this policy has been in place for quite some time, and so I would kind of like to know what AI programs and what vendors they're using, and kind of seeing what the contract process looked like for those, because this doesn't smell right in my view. But to that point, yeah, you need to keep your social media. I mean, personally, LinkedIn, that's the extent of my social media. And so maybe it's best for us as a society if we move away from those sort of things. But I know that's easier said than done. And so if you are having social media, one, I hate to say it, but don't say anything against this administration or anything against the country. First Amendment notwithstanding, but keep it open. Do not have anything private. All that's going to do, having social media, whether it's open or closed, is just going to prevent your visa processing. And so maybe it's best that we close down our Twitter, X, and Instagram accounts until we get a visa, until we kind of sort out the madness that's going on right now. And so again, that's me being a little bit more cynical than some others, but yeah, this is the policy. It is not a new policy. It's been around for at least a few years. And in that time, Rebecca, you see a little bit more frequently than I do in terms of consular issues, but I can't think of anything that we've seen for our clients where they've had any negative blowback for any social media issues.
No, not so far. I guess we'll see under the current administration. Along the lines of LinkedIn, like you mentioned, there was a cable from DOS to consular officers that accompanied the announcement last week that requires the officers to review LinkedIn profiles or resumes of H-1B and H-4 visa applicants, specifically to review them to see if they have performed work in areas that include activities such as misinformation, disinformation, fact-checking, compliance, and online safety, among others. Basically, they seem to be instructed to check people's resumes to see if they've done any work that could be perceived by the Trump administration as censorship of maybe right-wing views, online censorship of right-wing views, and that sort of thing. So that is another thing to potentially be aware of. I don't know that anyone would really have something that explicit on their LinkedIn profile that says my work involves censorship of certain political viewpoints, but that may be something to keep in mind, along with overall with this social media screening. Just be aware that because there's this increased screening, it's more important than ever to make sure your LinkedIn or your LinkedIn and your other social media presence, online presence, is consistent with what you're listing in your GS-160, is consistent with what is listed in your H-1B applications, in your PERM applications, as far as your employment history. Anything where you have listed your work experience or employment history, ensure that it matches what you are listing on social media. If your employer is an IT consulting company, but your LinkedIn profile says that you work for AT&T, for example, AT&T is probably your end client. But if you are presenting yourself on social media as being employed directly by AT&T, a consular officer could view that as inconsistent with what is listed in your H-1B petition or your DS-160. This has always been the case that you should ensure that everything that you have online is consistent with your immigration filings, but even more so now, it's important to make sure there's no contradiction between any of those.
And we've seen that very similar issue. I haven't seen it through the consulate, but I've seen it a number of times where they pull up someone's LinkedIn and I'm employed with Reddy Neumann Brown P.C. and we do consulting work. We put our folks on to end client projects. Reddy Neumann P.C., as proud as I am, we aren't Exxon. We aren't Apple. Global leaders in their field. And so people like to brag about themselves. It looks very nice. If I was an end client at Apple, I'm going to say I was working at Apple, as a software engineer or whatever the case may be. It looks great when someone clicks on our profile. Oh, this guy was working for these huge companies. He must be very, very talented. Be proud of your employer, one, but two, know that your employer was your employer. Apple was not your employer. And so if you're trying to leverage those sort of things, we've seen people's wrists slapped and worse from USCIS. Going one step further, this is a little bit different idea, but we've seen it where clients use, I'm Ryan, I create a fake resume and I give it to my company because it looks so good. Ryan's got all these skill sets that he has, and I pass along. The company doesn't know it's fake, but they pass along this resume to Apples, to the Amazons to get me placed on those projects. They look at that resume and they quickly figure it out. And so be very consistent. Of course, be truthful as the day is long when you're putting anything on your DS-160, on your labor certifications, on any employment history. We as humans like to inflate ourselves. There's nothing inherently wrong with that. But when we're dealing with this administration, there's just no value in making ourselves look better. We need to make ourselves look as real as can be. And so just a couple things that I've seen kind of in the day in, day out.
Okay, so the next topic we wanted to discuss is Prudential visa revocations for old charges and offenses. We had started seeing a few instances of this, mainly Stephen Brown in our office had reported seeing some of these last week, and then they are increasing this week to the point that it does look like it's becoming a trend. Basically, it's a situation where you may have had an arrest or a charge or a citation for some sort of criminal offense many years ago. Some of these are more than a decade old in the recent instances that we've seen, like an arrest for a DUI from 2012 or something like that. And the consulate, again, it's the consulate sending an email informing the person who had gotten a visa from that consulate that your visa is being prudentially revoked. So a prudential visa revocation, that only refers to the visa stamp in your passport. It does not affect your status in the US. It doesn't affect your work authorization in the US. As long as you do not depart the US, you're essentially not affected by this email that you get from the consulate about a prudential visa revocation. What they're saying is that we see something in your record that is causing us to basically revoke the unexpired visa stamp that's in your passport, so that if you depart the US again, you can't just use that existing visa in your passport to re-enter the US. You need to come to the consulate and undergo additional screening or vetting for this issue, whatever we think it is. In the past, prudential visa revocations, so they themselves, prudential visa revocations, are not new. They have been around for a long time. Typically, we see them in DUI cases where the consulate prudentially revokes a visa because they are concerned that this person is a health threat. Actually, for DUIs, it's under the health grounds of inadmissibility. And so the next time they depart the US, they have to go to the consulate and undergo a physician screening before they can get a new visa. The visa revocations that we're seeing recently are different because they are for very old offenses that sometimes happened, in most cases, they have happened prior to the person's previous international travel or recent international travel and getting visa stamps. So there might be an arrest or a citation from 2015. Between 2015 and 2025, the person has traveled multiple times. They've sometimes gotten visa stamps 2 or 3 times from that consulate. And all of a sudden now in 2025, the consulate is saying your visa is being prudentially revoked because of this arrest for something that we found in 2015, even though we've granted you 2 visa renewals since then, and you've traveled multiple times since then, and it hasn't come up. That's what makes these recent ones unusual. Usually that would not happen. If you had some sort of criminal issue, having gotten the visa from the consulate would kind of be a sign that they vetted it and they decided that it was not a problem. And that's why they issued you the visa in 2017 and 2020, for example. But now all of a sudden they're deciding it is an issue to the point that they're revoking the visa. And you would need to apply again at the consulate in the future. So if you are in the situation, you do get one of these prudential visa revocations. As we said, it doesn't affect your status or work authorization in the US. The main advice would be to not travel. Again, don't travel right now, because once you depart the US, no matter what the visa stamp in your passport says, you will need to go to the consulate again to apply for a new one. And I would expect that consular process to be very long and difficult under the current administration. I would not plan to go for visa stamping under the Trump administration. Unfortunately, it does seem like a long time, but realistically, it's going to be a very difficult consular processing process. So In the meantime, if you remain in the U.S., like we said, technically H-1B extension should be fine. H-1B transfer should be fine. Within the country, within the country, changes of status should be fine. H-4 dependents are not affected if, this Prudential visa revocation has happened for an H-1B visa holder. So for the most part, our advice right now is for people in this situation, maybe reach out to an immigration attorney to discuss and make sure you understand what the consequences are, but don't panic and leave the country, because once you do, then it becomes much more difficult to fix the situation or try to come back in. Yeah, Brian, did you have anything to add to that?
Yeah, I think people are a little bit more alarmed about the Prudential revocations than need be. Like you're saying, Rebecca, it's just a travel issue. Doesn't knock you out of status. I've been practicing since 2014. I think I've seen 2 or 3 of these visa revocations in that time. And like you were saying, it's mostly for DUIs. Now I think it's going to be pretty much for anything. I was overhearing my partner Steven saying that he had seen someone get it for tickets that were dismissed. Not even dismissed. The charges were never pressed, so they were arrested. And the court never even took the charge. And so it was just the arrest that triggered it. And so that's a little bit silly because, you could be arrested by mistake, pure mistake. And does that mean my visa is revoked? Let's hope not. But just something to keep an eye out for. I think part of this is an AI program that they're using. And the reason I say that is because a few months ago, if you guys maybe recall, they were revoking a lot of student visas and effectively saying that now you're kicked out of status. Stephen and his great work, as well as some of our colleagues in the field, the government, completely capitulated on that. It's still within their power, of course, to do this Prudential revocation, but if you're not traveling, it doesn't mean anything to you. And so your status is still completely valid. You can do changes of status, file your adjustment of status. None of this Prudential visa revocation stuff should have an issue for you if you're going to remain here physically in the United States.
Right.
So then the last one, the fun one from last week, one that's a bit of I think we just all rolled our eyes because it's just ridiculous. But what they've done is they've taken what was a 5-year EAD, and so there's a couple categories that they've put out for who this will affect. It's mostly people on humanitarian parole and TPS. But for our people, the folks who are on the call today, it is for people who have either a pending GC or are going to file their GC, their green card, the 485. And so what was a 5-year approval is now an 18-month approval. The government is saying that this is for increased vetting to make sure we're being secure and really just a load of nonsense. We've sued the government a number of times on I-485 delays. On green card and 485 delays. And we know that the only adjudicative factor of a 765 of that EAD approval is your 485 pending. It's one box to tick, one question. There is no vetting. If they wanted to vet you, they give you an NTA and put you in deportation proceedings. There's nothing they're going to find out about you by having you reapply for an EAD every 18 months. And so while the government says this is for vetting, making sure that we're being secure, I know it's nonsense. There's a George Orwell quote that political speech gives solidarity to the wind. And that's I think what the Trump administration is doing right now is they're saying this is for protection and they're saying it's for security. We know it's just to cause headaches for people. And largely it's going to be for the Indian community because that's the one, maybe 2 countries of birth that see the longest delays in GC adjudications with the backlog. And so if these EADs are only good for 18 months, you are allowed to file for your renewal within 6 months of expiry. We have a number of times filed it at the 8 to 9 month mark. So filing it early for sure. without any issues. We've been seeing the approvals. That was before this most recent policy announcement, but 100% know what 180 days is before your expiration on the EAD and file the extension. It's going to be $260, and so budget that out. For young kids, I know a lot of our clients will file the EADs for young kids. If the kid's not 14, 15, working age, if they're 8 and 9 years old, they're probably not going to work anyways. Save that money. But for mom and dad, the H-1B and the H-4 holders, or people who have just dropped off and they're using they've been using the GC EAD, keep an eye on your dates so that you're not having any gaps in work authorization. And then one more point that's now escaping me. I'm sure it'll come back to me at an inopportune time. But that's what it was. And so I've had a few clients contact me. Let's say it was a family of 2, a husband and a wife. Before the policy came out, husband, let's say, gets his EAD approved. And I've had a couple questions. Okay, my wife's is still pending. Is it normal that we've had it split out? Yes, absolutely. While it is a family, while they're probably going to approve the 485s together, those interim benefits, the EADs and the APs, it's I shouldn't say very common, but it's not atypical to see husband and wife, sons and daughters getting the EADs approved at different cadences. And so that comes to the question now, if I have a pending EAD, is this going to be a 5-year or an 18-month EAD window? By the policy announcement, it says that this will be applicable to pending and to be filed EADs as of 12/5. And so if we just read the pure language of the policy announcement, if on 12/5 you had a pending EAD, then we should probably expect that it will be an 18-month approval. This administration is as slapstick as it comes, and so it will not surprise me if we start seeing or continue to see 5-year approvals, and then eventually it will taper off and we'll start seeing the 18 months. And so just something to keep an eye out. So you may very well see the instance where you were approved last week and it's good for 5 years, but your family members are still pending. They may be getting the 18-month approval. Rebecca, do you have any thoughts on if USCIS could retroactively revoke the EAD and give 18 months?
I don't think so. Even under the first Trump administration, under kind of the craziest policies we saw, they never seemed to be interested in going back retroactively and revoking or changing validity periods for anything that was already approved. Mainly, they sought to affect anything that had yet to be approved or filed. So if you do have a 5-year EAD or advanced parole, right now, I think those are fine. Those are unaffected. We don't expect any changes with those. It's just anything that has yet to be issued for AOS applicants for the EAD, most likely, going forward, it will be an 18-month validity period. So you'll just kind of, unfortunately, be in a cycle of kind of every year almost working on a renewal of your EAD. So as Ryan said, just file as early as possible, at least 6 months before. If not, there's no harm in trying to file a little earlier. The worst case scenario is they don't accept the earlier, the 7 or 8 month filing, and you just file again at 6 months. You lose the filing fee, but if you don't mind trying, then we have done it without many problems. Okay, so I guess we can go to questions now. So I do have one from Sid Mohan that asks, can a H-1B amendment plus extension based on a minor salary annual increase be filed more than 6 months of the H-1B renewal date? Yes. So we have used this strategy frequently for people who are looking to file their H-1B earlier than the 6-month window that's normal for extensions. A lot of times, people want to do this in order to concurrently file an H-4 and EAD application and give the H-4 and EAD the best chance of getting approved quickly in premium processing as well. And so if your H-1B isn't due for an extension until 2027, but your spouse wants to, you just got your I-140 approved and your spouse wants to apply for an EAD, if your company is willing to file an amendment plus extension application now, it can be based on something like a minor salary increase, like you said, a slight change in the job duties. We've never seen USCIS send an RFE saying the change in the terms of employment is too small for this to qualify for an amendment. We've never seen that before. So any small change can be the basis of an amendment that would allow you to file that H-1B extension earlier. And a lot of times with an H-4 and EAD, that could be processed faster.
A question from Venkat on YouTube. We got to know last week that there was some civil litigation ongoing back home in India, and asks, what implications, if any, could there be for his immigration? He already has a GC, so congratulations on that one, Venkat. But regarding your citizenship and litigation, that's a civil matter. I'm sure it's just a run-of-the-mill property dispute. So no, that shouldn't have any impact on your GC. It's typically the criminal things that are going to impact, things that reflect upon your moral character. Those are things that can be used to deny a citizenship. But if you're just having a very typical property dispute over an apartment, I don't think that there's anything that you need to be concerned about.
We have a question from someone who has a scheduled appointment with the consulate this month. Their visa stamp expires in February. Can they attend only their biometrics appointment and come back on their existing visa if their consular appointment is postponed? I am not sure if you can do that, actually. That's a good question. What we've been seeing is that the biometrics appointments seem to still be going forward as originally scheduled. It's the main interview at the consulate that is being rescheduled for months later. That is a good question. I don't know if that is possible. I think theoretically you could, but if you are in a situation where your visa, if you're already outside the US and your visa appointment is being rescheduled, obviously you may need to just wait there for the new appointment. If you're not outside the US yet and you know that your appointment is being rescheduled, but your biometrics has not been rescheduled, I would probably lean towards just canceling your appointment and not going.
Biren asks a good question. This is more common than gives me comfort. Gets the I-140 approved, but they list the priority date incorrectly by a year. The priority date should be 2013, but they approved it with 2014. This is a typographical error. And what it's happening now is it's causing the lockbox to reject the 485. And so how do we fix this? Couple ways to go about it. We've seen it, plenty of times, unfortunately. First is to put in a service request or have your company or their counsel, their attorney, put in a service request for a typographical error. This does happen. They'll provide an updated receipt notice. An updated approval notice, properly reflecting the priority date. And so, service request is one. Two is you can give a cover letter. So let's say we are working on the correction and we want to file this 485 today. What can we do? One, put in the service request because they're going to give you a receipt number. We can put that receipt number for the service request on our cover letter. And then just apprise the officer. Officer, I have a pending, or I have an approved I-140 with this labor certification. This labor certification has this priority date. We filed our I-140 on X date. It was approved on Y date, but USCIS approved it with the wrong priority date. Here's my labor certification that shows what the correct priority date is. That should get it through the mark. And so we either get the fully corrected I-140 approval with the service request, which the government should be giving. But if we have to act today, club together as much as you can to apprise USCIS of what the priority date is. That's going to be your labor certification, copy of your I-140 approval notice, give a short paragraph detailing what the issue is. We have seen this before. We know that we can get it through the lockbox. But if you're just kind of slapping some documents together and hoping they figure it out on their own, you can't trust USCIS to do that, and so you have to hold their hand. And so maybe put it on a brightly colored sheet. Hey, incorrect priority date on the 140 notice, supervisor review, something along those lines. But you can absolutely get it through. You just have to kind of massage the system in the right way.
I'm seeing some questions from different people about whether travel on an existing visa stamp is fine. If you're not needing to go to the consulate to apply for a visa, can you travel internationally on your existing visa? As of now, yes, I guess. But I mean, our advice this year on, for example, when the $100,000 fee proclamation came out, there were a lot of questions. Does this apply to me? Can I travel if it doesn't apply to me? So technically, yes, you can travel on your existing H-1B visa. We would still advise caution to avoid unnecessary travel if possible, because, I mean, we kind of see the speed at which, some of these proclamations are being implemented. The fee proclamation was announced on a Friday afternoon or evening and was in effect by midnight that Sunday. For this, the social media vetting expanded online presence review was announced last Wednesday, and this Monday, people are getting their appointments, delayed by months. The current administration is, announcing things and implementing them very quickly. Sometimes they announce things without even a clear plan on how to implement it. And even though this particular proclamation or this particular policy may not affect you, we don't know what else will be announced that could affect you and might be implemented with little notice. So just to avoid a situation where you're outside the U.S., something unexpected gets announced and you're having to scramble to get back into the country, that's why we kind of advise caution on international travel right now, even if you have a valid visa and do not need to visit the consulate.
I saw a question a moment ago. So Anant, no, it wasn't Anant. The question was essentially, company filed the perm in November 2025. H-1B is set to expire with recapture in May 26. The question was, will I be able to do a 1-year H-1B extension? My view is that no, you would not. You would need that perm to be the priority date of the perm. You need to be at least 1 year old on the day that you're requesting the H-1B extension. And so by the fact scenario that you put in there, I would say that no, you would not be getting the 1-year extension.
We have a question on how will the latest announcement about the social media review apply to H-1B renewals or extensions? Could those be denied based on social media review? Not as much as at the consulate. So definitely the government's authority is always broadest and their discretion is broadest for individuals who are outside the United States who are seeking admission. So the government has a lot of leeway if you are physically outside the U.S. They have a lot of discretion. There's a lot of deference given to consular officers' decisions. It's very difficult to appeal or seek review of decisions by consular officers. And there are very limited ways to, sue in federal court. Whereas for people in the U.S., on a valid H-1B, if there is an issue for an extension, there are a lot more procedures the government has to go to try to revoke an H-1B. They have to send a notice of intent to revoke to the employer. They have to give an opportunity to respond. If it's denied, there is the opportunity to appeal. If that is also dismissed, there's the opportunity to file litigation in court. So we're not seeing so far, definitely we're not seeing any effect on H-1B extensions. We're not seeing RFEs or notices of intent to deny or revoke H-1B extensions or transfers based on things that they are finding in social media accounts. Also, this announcement is very new. It's barely a week old that they announced this expansion of the online presence review to H-1B and H-4 applicants, so they may not have gotten very far at all yet. We can't say for sure that in-country applications won't also eventually start getting affected by these, increased vetting procedures. But so far, we're not seeing any of it because, it's much easier for them to apply this to people who are outside the U.S., which is why we caution against unnecessary international travel so much because, once you put yourself outside the U.S., the government has a lot more leeway to keep you out of the U.S. It's much harder. It's much easier for them to just keep you outside the U.S. than for you to already be here and for them to remove you.
So there was a question earlier. We've been talking about not traveling for stamping. Someone asked, I have my GC. Can I travel? I would say, yeah, not a problem at all there. Just make sure that you're traveling with your green card, so to speak. Make sure that that's not expired. Make sure your passport is valid, and other than that, you shouldn't have any issues. A similar question was asked. H-1B extension is in process. Can I renew my passport? I would say absolutely, and so there's just no issues there.
We have a question on, are there any chances of an H-4 EAD being approved early if bundled with an H-1B and H-4 in premium processing? Yes, so it's not guaranteed, but the best chance for an H-4 EAD to be approved quickly is if it is filed concurrently with an H-1B and H-4 in premium processing. It's no longer mandatory for the government to bundle all three applications together. The legal settlement that required USCIS to do that expired in January. And of course, the current administration was not interested in extending it. So it's not guaranteed that they will all be approved at the same time. But in our observation, I would say the majority of cases still are. If the H-1B, H-4, and EAD are filed concurrently, probably about 50 to 60% of the time, they're still being approved at the same time. At the same time still means probably within a month of each other. It's not usually not going to be the exact same day that all three are approved together, but normally the H-1B is approved, and then in about 2 weeks, the H-4 EAD are approved too. If they are not filed, or if they are not approved together, then what we'll see is the H-1B gets approved and the H-4 and EAD will remain pending for months afterwards, like 3 to 4, maybe 6 or more months. But that is maybe happening in like about 40% of cases, I would say.
There's a question about the Child Status Protection Act. Fidget Diamond Girl asks, we filed a concurrent 485 and I-140 while everything was pending. The dates have retrogressed. I-140 is approved now. I've lost the rest of the question. The daughter's currently under 21. Will she be eligible for CISPA before 2025? And so I have a couple thoughts here. One is that the Trump administration has now changed, let's say, the Biden era CISPA calculus, not the calculus, the applicability, where now we have to look at the final action dates chart. And so once your date is current under the final action dates chart, that day is what will lock in your child's age. Biden era clarified the rule for us and gave a good benefit to immigrants by saying we're going to lock the age as of the dates of filing, not the final action dates chart. Dates of filing chart is almost always more advantageous. And so my thought would be, if your date has not come current yet at all under final action, you're still waiting on the CISPA. My question to you might then be, and this isn't something that you can answer in front of me, you have to answer it for yourself. When was your I-140 approved? If it was approved, let's say, I don't know when the new Trump CISPA rule came into effect, let's say it was March 2025. If your I-140 was approved before then, I would then argue that the date was locked in on the date that I-140 was approved. And so if maybe the 485 comes, maybe it takes a few more years, and they say the child can't get it under CISPA, I think that's a very ripe case to sue, because under the law that existed at the time, you were locked in. where Trump now comes into office, changes the calculation slightly. We have to look at a different box. It knocks the kid out. And so we can't have that conversation right now just with the platform, but something to consider. But CISPA can always be funny. It's always something that you have to look at in that moment on that day to see whether we're going to be saved or not. And so sorry to kind of give an open-ended answer there.
Let's see.
Rebecca, here's a question. I don't know if you know. Is there a time period going backwards that we have to list our social media? For example, I haven't had Facebook since law school. That was well over 10 years ago. I had MySpace in college. That was 20 plus years ago. If I've closed down all my accounts, maybe I closed it down today, I should probably list it on my DS-160 tomorrow. If I closed my accounts a few years ago, do I need to be notifying USCIS or DHS of these?
I believe you do. It depends on the wording of the DS-160. I'm trying to pull up a draft right now. I think the question is along the lines of, okay, let's see. Have you used, well, it just says, do you have a social media presence? And then it asks for social media provider or platform, social media identifier. And then there's another question that says, have you used additional social media platforms in the last 5 years? So this is from the DS-160. So it sounds like, first it asks about your current social media presence. And then there's also a question that asks, have you used additional social media platforms in the last 5 years? So yeah, so closing down your accounts right now probably will not eliminate the review of those accounts. If you have used them at any point in the last 5 years, you still are required to disclose it on the DS-160 form. I don't recommend, closing it down and then not disclosing it on the DS-160. If it was in use in the last 5 years, I would just assume that the government will find out about it. And so just be upfront about it if you've used any of them in the last 5 years.
But let's say the H-1B just got picked up. Is there any issue continuing your course of studies? Can you study while you're on an H-1B?
Yes, that's not a problem. You could, be enrolled as a full-time student at a college or university, and also, while you're on H-1B status, as long as you are continuing to comply with the terms of your H-1B petition. So if you're working full-time on the H-1B, as long as you can do both, that's fine. That's not a problem.
Someone asks, have you seen any issues with people traveling on advanced parole? I haven't seen or heard of anything. We've had, when Trump first came into office and there was that whole, parole is gone, I think that confused a lot of officers, where some of our Indian clients were put into secondary inspection, and then the supervisor came down and slapped, the officer on the back of the neck saying, what are you doing with these people? And so I haven't seen any issues for like GC advanced parole. I haven't seen any issues whatsoever. And the same goes for like reentry permits. So let's say you filed your 485, you get your reentry permit, you leave for maybe a year, 18 months, and then return. I haven't seen any issues on reentry permits either.
Right. For the most part, advanced parole travel has been fine. If you do have any sort of criminal history, though, even if the charges were dismissed or expunged, if you have any criminal record or anything in your history that could be construed as a criminal record, I would probably reach out to an immigration attorney to discuss before traveling on advanced parole. That would be the only situation. Besides that, travel on advanced parole is pretty much the only kind of relatively unaffected situation at the moment for international travel. So we have someone who says their H-4 EAD has been pending for more than 8 months at the Texas Service Center. So if you do have a situation like that, that is So reaching out to USCIS, doing a service request, following up with your congressperson, you could do all those things, but in our experience, they are not that effective. In our experience, the most effective way to force USCIS to adjudicate your case when it's been delayed beyond the reasonable processing time like this is to file a lawsuit in federal court, an H-4 EAD delay case, which Stephen Brown in our office has done many of these with little issues. You know, he's still filing these, and so definitely more than 6 months, your situation would be a candidate for a case like that. So if you are interested, you can reach out to Stephen in our office.
Someone that has their GC, had a DUI in the past, and has traveled 2 times, asks, is there any risk traveling with this new administration? I would say, yeah. It's a gamble, whether it's a 50-50 or 1,000 to 1. I'm not going to opine on that, but it is a risk. So I just ask you, is your trip abroad worth not being admitted back into the country? Depends on how long you've got left on your GC, but once you've got your citizenship or once you've applied for the N-400, the DUI, if it's outside of 5 years, should not impact your citizenship. But once you've got that citizenship and you're going to travel on a U.S. passport, I think those issues of the past DUI are then behind you.
We have a question on, can an H-1B visa holder do day trading? Yes, that's fine. So the rule for H-1B visa holders is that as far as employment, you're only authorized to work for your H-1B sponsoring company. Investment is fine. Receiving income from investment is fine, as long as it is considered passive investment, meaning you're not actively managing that investment like a business or a rental property or several rental properties where you are actively involved in managing it. That starts to look like unauthorized employment if you are actively involved in it. But day trading, where you are just buying and selling stocks, even if it occupies a big part of your day and takes up a lot of hours in your day, because it's just a matter of you're investing in companies, but you're not involved in the management or operation of those companies. Technically, on an H-1B visa, that is fine, doing day trading.
Someone asked, and I've lost the name, but asked what for EB-1A or O-1 purposes, what's considered a high salary for an electronics or an electrical engineer in the Bay Area? Depending on who you talk to as an attorney, whether you should focus on the Bay Area, whether you should focus globally, I think that's an academic discussion that can be had. The gentleman or the lady mentioned they make about 147. That's a very respectable salary. Absolutely. I think any one of us would be happy to take that home with us. When it comes to the EB-1A, there's a number of ways that you can make your salary work. I should say there's ways that you can present it tactically. For me, I like to see people with 200K and above. We've certainly seen EB-1As approved for people making 100K, 147K in the instance of the question. I wouldn't say that that's the strongest number, but I also wouldn't tell you do not try that. Sometimes we do everything above board. We don't do any misrepresentation. We don't do any fraud, but sometimes we have to be creative and shoot as many arrows down the range as possible. And so, for instance, maybe you don't have that 200K salary. Let's just tell the government anyways, hey, this is what I make. Consider it. Will you consider it? Maybe they give it, maybe they don't. You're not doing anything wrong. You're not punished by them not granting you a criteria in your EB-1A case. So that means try to leverage as many EB-1A criteria as possible. You don't have to try to hit all 10. For a lot of you guys, your careers are probably not in performing arts. And so really it's 8 of these criteria that would be available to you. You don't have to hit all 8. But if it's a matter of, should I use my salary or not? I would say absolutely. As long as we're not misrepresenting anything to USCIS, there's nothing wrong with presenting numbers that they might not say that's extraordinary. And so nothing wrong with that.
I saw a question from someone whose H-1B employer, the company, is being bought out, and they are asking, does this require an H-1B amendment or a transfer if the contract is unaffected? I assume the client contract, maybe for the project they're working on, still exists. Is an amendment or transfer needed? So if it is simply a change in ownership of the company is still operating as the same company with the same tax ID number, the same federal employer ID number, but it's just a matter of a change in ownership. But your payroll is still coming from the same company with the same tax ID number. Technically, nothing needs to be done in that situation. There's no amendment or transfer needed. Technically, you don't even need to update USCIS at all. They don't need to be notified of a change in ownership of the H-1B petitioning company. If the purchase of the company results in like a merger, such that the company that's running your payroll will change. It now has a different tax ID number. The entity that your payroll is run through is not the same entity with the tax ID number that's listed on your H-1B petition. That could require some further action. Basically, if the new company, if the new employing entity agrees to assume the existing immigration liabilities and obligations of the previous company, and they sign the paperwork at the time of the merger that confirms that, and that lists out your specific LCA number and maybe your perm case number if you have a perm ongoing, then that's known as a successor in interest situation, where also an amendment and transfer isn't needed if the terms of your employment aren't changing. If you're still doing essentially the same job in the same location at the same salary, there's also no need for an H-1B filing with USCIS. It's just that at the next extension, when your extension is due anyway, it would be filed under the company's new name and tax ID number, and they would include documentation of the successorship relationship, and explain to USCIS that, you know, this new company is the successor to the previous company, and that's how that would work. If the new company does not assume the existing immigration liabilities and obligations, in that situation, it would be a transfer. An H-1B transfer application would need to be filed by the new entity in order to authorize you to work for that new company and have your payroll run through that new company. So the triggering event really is a change in the company running your payroll. If that is changing, that's when extra analysis is needed.
Here's a good question. Probably take one or two more. Submitting secondary evidence of the birth certificate along with the non-availability certificate, should I provide the original affidavits from my parents and relatives, or will the copies suffice? Copies are fine. I don't think I've ever seen USCIS or DHS requests for the originals of those. After all, you're passing along a sworn document, whether it's original or not. The solemnity of the document remains. And so I would also include maybe your PUN card, your other card, and your school leaving certificate, just to go a little bit further. But this RFE type is very common. It's very, very, very rare that we see any issues after we've responded. So I think that's the hour. You want to do one more, or are you good, Rebecca?
Yeah, we can end it here for today.
Okay, perfect. Thanks for your time, everybody. We'll do it again next week. We don't know if there'll be old faces or new faces, but we appreciate your time, and we'll talk to you guys again soon. Thanks.
Thank you.